All right, welcome everybody. And we are doing an impromptu Friday just conversation. Of course, it's an immigration conversation with our newest senior immigration attorney, Attorney Wilson, aka Attorney V. And we're just going to be chopping it up, discussing immigration, everything new, everything current, everything trendy, and hopefully you'll learn a thing or two about it. So, Attorney V, pop it off.
All right.
Introduce yourself.
Hi, everyone. I'm Vanessa Wilson. I've been practicing immigration law since 2016. I've been an attorney since 2008, so I've got a criminal law background.
Yeah. I still don't understand how you've been practicing since 2008. I mean, I graduated undergrad in 06.
Time travel. No, I just look younger than I am.
Oh, okay. Because I'm like,
it's in the
genes. Okay, that makes sense.
I went straight through too. I went high school, college, law school, practice. I took no breaks. So I was a baby lawyer as a public defender and stuck with it until we moved to sunny Florida, where I switched to immigration and just been.
So you were practicing in New York first?
I was.
Okay. But you were doing criminal?
Yes.
All right. And you were a public defender?
Yep, at the Legal Aid Society.
Yeah. So here's the money question. Is it true that there's no public defender that has a winning record?
Interesting. So I don't think I've ever heard it put that way, but I would like to say that is not true.
Really?
Yes.
There are public defenders out there with winning records.
So here's the thing. You got to define winning, right? Obviously, we're lawyers. We care about words, right?
Exactly.
So how do you define winning? So for me, winning is, not going down for what they tried to charge you with, right?
Okay, yeah.
So at first, you get accused of a crime. The cops write up whatever they think is the right offense for that alleged crime. They take it to the prosecutor's office. Prosecutor might bump it up, make it worse than what the cops said. They might bring it down if they don't think they agree with the cops. Then you're charged, right? At that point, you meet your public defender and you meet your judge. There might be an offer on the table to reduce the charge or at least get a low sentence. But if you're not interested in that offer, you want to challenge it, go to trial, plea bargain.
So it depends on what's a win.
Exactly. What's a win for you? If you
what's a win?
Did the crime,
yeah.
A win is less jail,
exactly.
maybe a lower charge, right?
Yeah.
If you didn't do it, obviously the ultimate win is dismissal and getting it sealed. But
like I saw
stuff in between.
I saw a meme the other day where this guy, he said he was super happy because he didn't go to county jail for 30 days, but he's on 6 years probation. That's not, but he's happy. Yeah, that's not a win.
He's not incarcerated. For him, that was a win, right?
Yeah.
He wants to be outside, not in, right?
Yeah.
But for me, personally, I would not want to do that. I would
6 years
almost
probation,
rather do the time if it meant a lower charge or no charge. I don't know.
Yeah.
Something that was less. Because 6 months probation is probably a felony on his record now, right? So,
Yeah, exactly. So then you moved to Florida and you're now doing immigration.
Yes.
So that means you were through Trump round 1.
Yes.
Okay, and then here you are again. So why did you switch over from criminal to immigration?
So in Manhattan, I think a lot of people know how diverse the city is.
Yeah.
The Legal Aid Society is one of the oldest, or maybe the oldest, one in Manhattan, public defender agencies in the country. And so with that pride comes really good training. And we had very intense immigration training from day one. And it was I started practicing shortly after Padilla.
Okay.
So Padilla came out in 08. I was practicing in 08.
Yeah.
We have all this mandatory immigration training.
Hold on. I know what Padilla is, but tell people what Padilla is. What are you referring to?
Padilla is a Supreme Court case that requires criminal defense attorneys to inform their clients of the possible consequences that a criminal case will have on their immigration status if they're a non-citizen.
Yeah.
So now you're a criminal lawyer, you study criminal law, you're at criminal court day in, day out, but now you have to tell this client what might happen as far as immigration law.
Exactly.
It's kind of malpractice if you don't study immigration law, right? So
absolutely.
We were trained on immigration consequences of criminal cases.
And it's interesting that in that jurisdiction that they do that, because I'm sure you've seen this already where we have the client that has a criminal charge.
Yeah.
They're in state custody and there's an ICE hold, but they don't understand the difference where we're trying to tell them, hey, it doesn't matter if you pay this bond to the state.
Home.
You are not going home. You're going to actually go to immigration court. So let's try to resolve the criminal part before we get to immigration court, right?
Yeah. I mean, there's just so many moving parts.
Yeah.
You know, you've got the state jurisdiction, you've got the federal jurisdiction, that's where immigration comes in. And honestly, I mean, this is something I felt the first week of law school. People don't understand the judicial process. And it's hard. There's so much to it. And I wish everybody had an explanation of who is in charge of what and what it is exactly that they can do or can't do.
Yeah.
Right? So if you have a criminal case and you're eligible for bond on the criminal charge because maybe it's a low-level offense, but immigration is now coming after you and setting this ICE hold because we don't care how low-level this offense is in that state, we still have a problem with it.
Exactly.
Like marijuana, for example.
Absolutely.
So, you know.
Yeah. Like one common issue that I've been seeing this year is people saying, hey, I'm going to file for this, and I'm seeing their criminal history and they're like, no, it's fine, I got it sealed or expunged.
Right.
And I'm telling people, it does not matter if you paid and you got a criminal record sealed or expunged. That's only beneficial on the state level, meaning it's only beneficial if you're trying to rent a place, you're trying to get certain jobs. But when it comes down to immigration, it follows you.
Yep.
Right? You can't expunge something off your immigration record if you are an immigrant.
Yeah, the way I try to explain it to people is that immigration, because it's federal and they've got all these different jurisdictions to deal with, they're not going to go and know each state's criminal laws.
Exactly.
They have their own way to view all of the laws as a whole. So it's an aggravated felony. Is it a crime involving moral turpitude? They've got their own standards that need to be met or disproven in order for them to decide if it's going to have a negative consequence to your immigration status.
Yeah.
Right? So, you know, if you're not aware of that and you take a deal because it seems like it's a good deal at the time, it could still have immigration consequences and you might find out too late, unfortunately. So
so I mean, in other words, don't take a plea deal in state court just because the attorney says that, no, it's a plea deal and the case is going to be done soon. No, if you are an immigrant and you take a plea, and a plea means that you are admitting to guilt. Even if on the paper you tick not guilty and it's like a no contest, for immigration purposes, you are still guilty and that is going to follow you. The only benefit that I've seen with that is, say for instance, like a marijuana possession. Right? Because Florida, they have amended their laws where marijuana possession of 20 grams and lower, it's no longer deportable.
Right.
You know, but if you're in another state that doesn't have that, you are deportable.
Exactly. I have a case like that now where, so in New York, where I was a public defender, first time possession, small amount of marijuana, you would get what's called an ACD. It's adjournment in contemplation of dismissal. It just means we're going to give you a court date a year from today. It's adjourned. If during that time you have no new arrests, no nothing, we're going to just dismiss it. You don't even have to show up, or at least that's how it was when I was there. I don't know if anything's changed, but so we're just going to dismiss it and seal it. This means you didn't plead guilty, you didn't admit to anything, they didn't even test the leaves in the baggie to make sure it actually was marijuana, right? Okay, so the case is just done and closed. While it's open, it could be problematic for you for immigration purposes, but at the end of that year, it's literally gone, right? So I have a case right now where, in his case, it was first time, but the amount was too much for them to get him that deal. They weren't willing to give him that disposition. So he ended up pleading to a higher version of marijuana possession, and that has stuck with him. So New York has decriminalized it, so it's gone from his New York record. But immigration is like, on that day, you said, yes, that was my marijuana. That's all they care about. So again, people, like, once you're an immigrant and you admit to any type of criminal infraction, you cannot expunge it away. And because we're now in 2025 in Trump round 2,
it's a whole new ballgame
Yeah.
as it relates to you getting a notice to appear before an immigration judge. So we can kick it off right there with the Trump changes. So the Lake and Riley Act, right, which basically states that if an immigrant is convicted of certain crimes, but they say certain, but I say most crimes.
Anything, honestly.
Anything.
I don't think the arresting officers care. They see if they're meeting you and you're not a citizen, they're kicking it up.
And it's now a mandatory detention.
Yeah.
Right? So how are we? So I say we know people because Attorney V, she is now my right hand, a huge part of the engine of the Sekou Clarke Law Group, spearheading the deportation proceedings, bond hearings, etc. How are we handling our clients who they're now in mandatory detention?
Mandatory detention is hard. So the statutes haven't changed, right?
Yeah.
The Lake and Riley Act may have added to the interpretation, but the original statutes on who is mandatory detention has not changed. So we can still make those arguments in court. These are things, there's lawsuits every day. ACLU, who else? Like private attorneys, class action groups, they'll sue immigration every time, or they'll sue the authorities that be every time something comes down that unfairly affects a lot of people. So just because it's been passed, or it's a bill and it's about to be passed, or whatever stage it's in, doesn't mean that that's forever, right?
Yeah.
So I think that we can still make the same arguments that certain charges are not mandatory detention.
Yeah.
That is definitely why it's important to have an attorney at that stage, because the words of the law that you were charged under matter.
Exactly.
I was actually just on the phone a few minutes ago with a criminal defense attorney who his client has a methamphetamine charge in Florida. I still have to do the research on that, but I know the methamphetamine charge in California does not have the same consequences as other states.
Exactly.
So methamphetamines, it's not straightforward depending on how the law is written, how they use the words. If it's too vague, you might be able to argue you are not mandatory detention. So, and it is a deep dive. It's not a quick thing.
It leans into a lot of the videos that I've made trying to explain to people that just because you're detained by ICE, it doesn't mean that you're going to get deported. Right? Just because you received that notice to appear, of course, it's super, super scary, but it doesn't mean that you are going to get deported, right? There are still arguments that can be made. And don't listen to the Google experts who are saying that, no, once you get detained, you'll go home. It doesn't even matter if you get an attorney. That's the craziest thing that I've heard.
I've been seeing that too, that, they're accusing attorneys of taking cases when they can't even help them. And it's like, actually, I need to know if I can help you. I can't tell you for sure up front, especially when you've got a complicated case like that, right? Complicated cases, I need to do the legal research. We need to at least see what strategies can we pursue in your case. And there are wins even in those scenarios.
Absolutely. What are some of the biggest changes now that you've seen in practicing under the Trump administration as it relates to deportation or ICE?
I'm seeing a lot of cooperative. So this refers mostly to people who have entered at the border.
Yes.
Right? And I'm not talking someone who snuck in and is not on immigration's radar. This is someone who went directly to a port of entry of customs on the border and said, I want to apply for asylum. I literally just ran for my life from my home country. I want to apply for a humanitarian benefit. Please help me. And, they let them in. Sometimes they might detain them for a few days. They release them. What kind of documents they get when they're released, that's, I don't know. Depends on the day of the week, I guess. I don't know what's going on at the border. But sometimes those documents include a requirement to report to ICE regularly, right?
ICE check-in,
And the ICE check-ins, I feel like, used to be pretty straightforward. You check in, you say, my address is still the same. I've got this application pending, I've got this court date, or I don't have a court date yet, I'm still waiting. Whatever your scenario is, you checked in, you're done, you go home. What the changes that I'm seeing now are people getting picked up at their ICE appointment.
I know. And just to put a pin right there, now under this administration, we're seeing, as you said, people getting picked up at the ICE check-in that they're required to do.
Right.
Or they're getting picked up at court.
Right.
Or they're getting picked up when they're seeing their parole officer.
Yeah.
So it's like, no, I mean, they're trying to do the right thing.
Yeah, like maybe there was a mistake made in the past. Yeah. Maybe they didn't have a visa when they enter, but at least detention is typically supposed to be for someone who's a danger to the community or a flight risk.
Exactly.
The last person who's a flight risk is someone who comes to their appointments on time.
Exactly.
Right?
But I have a theory for that. But tell me your theory why we're having people getting picked up at these places now. I have my own personal theory.
I'm a little jaded. I think it's like a quota, right?
Yes, exactly. Yeah.
They just want numbers. They want to show off that they're picking people up. Look at all the people we've detained. We're doing such a good job with detaining illegals.
So we're aligned in that, yeah.
And all that.
And, I've said, and I've been saying this for the last couple of months, and finally a judge has actually backed me up. I said that initially they were targeting certain groups of immigrants, right? People who have removal order, criminal history, danger to society. But I said this a couple months ago that if you look like an immigrant, you're going to get picked up. And people are like, who looks like an immigrant? But an appellate court judge just ruled last week or 2 weeks ago that based on the evidence that she had in front of her, right? ICE can no, so she's upholding an injunction, right? That ICE can no longer target people based on the language they spoke, employment, and their nationality.
Right.
And if she has the evidence to show that ICE was arbitrarily targeting people, not based off the databases that they have, not based on prior convictions or prior removal orders, just based on them going into communities based on how people look, speak, or by their work, they were targeting people.
Yeah.
So now the courts are saying that is happening.
Yeah, I mean, to me it's obvious. Right?
Yes, right?
I mean, unfortunately these judges, they don't live necessarily in the worlds that we are all living in. I mean, of course they're people, right? I'm not gonna say judges aren't people, but they don't see people get pulled over for no reason at all. They don't see the chicken factory get raided on, when the chicken factory is E-Verify, like they are E-Verify compliant. So what's the raid for? They don't see that. They don't know that that's happening in their day-to-day. We're the ones getting the calls from our clients who are like, oh, my cousin got picked up by ICE. He was in the wrong time, wrong place. It's like, no, he wasn't. He was in his community with other people who look like him. And they roped him up. They just included him in the in the arrest process. So it is very unfortunate. I mean, I think the weirdest thing I've seen so far in my own day-to-day was that I was driving to work one day on the highway. I saw I think it was an ICE vehicle. And I was like, well, what do they do on the highway? Like, they were pulled over and there was another car that they had their lights on, like they had pulled over another car. I'm like, well, how does that happen? Like, did you follow them from their house? Did you know who they were before you pulled them over? Or is this a random stop? And what authority do you have to stop them? In a traffic stop, right? I just didn't understand. I would love to know. I kind of wanted to pull over too and find out, like, hey, can I help? But I didn't want to take that risk. So, but I am very curious as to in what scenario is ICE pulling somebody over? I need the details.
Tell me about, like, a case in your mind where you got someone out of ICE custody that you thought it was like an impossible case to win, but you got the person out.
Well, I almost don't want to say.
Just the facts. Just the facts.
Oh no, I'm not going to mention any names, but I feel like I'll give you two. One where it was because I felt like I made really good arguments. It had to do with their criminal record, and where they thought it was mandatory detention, but it turned out that it was not, right? So just going through the statutes, usually at bond hearings, they're kind of impromptu. They can be pretty rushed. We, as the attorneys in the background, we file the motion, we collect evidence, we try to prepare as best we can, but we don't always have access to everything, right? In this case, I happened to have access to his record, and I was able to make arguments as to the status of his case. I was like, well, this was dismissed. He didn't actually do that. This was a false claim. This isn't what you think it is. Maybe they charged this, but ultimately the plea was something completely innocuous. Like, he's not even deportable. Okay, and because of that, that client was released. So that I felt
based
like,
on the legal arguments that you made.
yes, that one I'll give myself, the pat on the back.
Yeah.
The other one I got lucky.
Yeah.
Okay, because this woman entered at the border.
Uh-huh.
She was paroled. 212 D5, which is a specific statute where they will release someone, giving them the authority to just be in the country and knowing that their case is going to proceed in immigration court, right?
It's a release on their own recognizance.
Yes, but it's a different document.
A different document.
Yeah, there's one that doesn't give you any benefits. This particular type of release you can actually apply for work authorization, right?
Okay.
So she's out on that status due to matter of Q Lee, this new case that came out this year. Under matter of Q Lee, she's not eligible for bond, but they weren't aware of her 212 D5 parole. They just knew that she was picked up at her ICE appointment. And I played up all of the mitigating circumstances that I could. I was like, she's got 2 kids under 3 years old.
Yeah.
She's not a flight risk. She appeared at her appointment on time. The appointment was set 3 years ago.
Wow.
And she remembered. Okay? Yeah. This is not like, come back in 2 weeks and, she just happened to show up. She remembered from 3 years ago to come to her appointment. She came on time, and that's where they picked her up. The young kids, no criminal history. What else she had a lot of positives. She didn't have her own independent asylum application because she didn't have a case in court. They just never filed it. This is the government's fault that it's not filed, right? There's nothing that she did wrong. But her spouse filed, and her name was in her spouse's application. So being able to show all that evidence.
And this is what you had to present as the attorney.
Exactly. Yeah. So I presented the birth certificates, I presented all the appearance notices, I presented her copy of her asylum application. The only thing I didn't present was what the government probably should have presented was the parole document. Yeah. They failed to do that, and the judge released her. Yeah. I mean, he set bond, but it was a nice low bond.
And I mean, that's huge because now under Trump, if you've entered within the last 2 years, or if you've been paroled in, it's significantly harder to get that bond if you don't have the right relief.
Right.
Yeah. Wow. Interesting. For me, I'll never forget this case. This Jamaican client of mine was incarcerated for a gun charge, for a gun possession charge, right? And the case turned on with me arguing the case that the gun didn't belong to him. So the judge and the attorney, they were like, how can he not know that the gun isn't his and he's the one driving it and it was under his seat? Okay. And the client's testimony was like, I borrowed the car from somebody, I don't remember his name. So they were like, you're not credible.
Yeah.
So I asked him, I was like, what's his name? And he said something like Blacker. So they're like, how do you not know his name? And I said, Your Honor, in Jamaica, and my people, you can back me up, most people have nicknames and do not know the person's real name for years. I have teachers, I have people that I've known for years. Yeah. And that's what it really turned on, more of a cultural thing, and then the judge let that one go. Yeah. And we got him out.
That's awesome.
So sometimes, you can make legal arguments, but you can make discretionary arguments that it leans on the discretionary relief of the judge. Yeah. So I'll never forget that one. Yeah. All right. So moving on. Changes under Trump. Visa overstayers.
Oh gosh.
DOJ, USCIS, they have said that they're now targeting visa overstayers, especially through screening, social media. Like, what have you seen as it relates to the treatment of people who have overstayed their visas now?
Well, it actually worries me a little bit because I'm like, wait a minute. Yeah. Marriage to a U.S. citizen, typically, that would result in a waiver of that overstay, right? Exactly. But I have seen at least 2. I think one was an RFE maybe, and one was a notice of intent to deny from USCIS, where they're like, well, you didn't maintain status. And I'm like, excuse me?
Exactly. Like I see that. Like, yeah.
Yeah, I'm like, and?
And what? Yeah.
Yeah, so why you didn't maintain status? That's assuming that you find the marriage credible and you approve this green card based on the marriage to the U.S. citizen, you're going to waive that, right?
Absolutely.
So why are we even talking about this? Like, get to the point Of the marriage interview. Isn't that why we brought the marriage interviews back?
Because that's the relief, right?
Right?
Yeah.
So do the marriage interview.
Yeah.
And only if the person is not eligible. If you think that their marriage is fraudulent and you want to deny it, now you can bring up this visa issue. But now they're bringing it up before.
Yeah. But no, one thing that is affecting those type of processes is the USCIS officer, which is another change under Trump. The USCIS officer now can make their own determination before the interview that this visa overstay, this marriage is incredible, and boom, denied.
Right.
No RFE, no notice of intent, boom, denied. And within 30 days, you're getting a notice to appear before an immigration judge.
Right. Yeah. Well, if they're that efficient. I don't know. I don't know that it's happening exactly in the 30 days, but they're threatening to at least.
I've seen it. I've seen, in the consultations that I've done, in May and June, I've seen at least 3 people where they come during the consultation. Yeah. They bring the denial, right, and it has the date. Then they call back
with the NTA.
With the NTA within the same month.
Wow.
And I'm like, I've never seen it. So I saw the first one, and then when I saw the other 2, I was like, wow, people are getting how are they this fast?
I'm shocked because I've been thinking that they can do it within 30 days, but I didn't think that it was actually going to happen that quickly. Yeah. At one point, I remember the NTAs were in the same envelope as some of the denial notices. Some of them,
I've never seen that one.
It would be attached. Yeah, it would say, and to me I thought that was as efficient as they could get. Right?
Yeah.
I didn't think that. Yeah. I mean, how many times have you tried to send something on a pending case? And first, you got to track down which office. Because you file an application to a lockbox, it gets transferred to the service center, and then right before the interview stage, it goes to the local field office. So it gets bounced around. Yeah. But if you had something to add, this is before the online system now. If you had something to add on paper, you had to figure out which office it was at before you mailed it off. You mail it off, and you never hear anything.
At all.
Ever. So you have no idea if they got it. All you know is from your mail tracking. Yeah. Right? So I was like, if they have a problem receiving mail, then there's no way they're going to send mail that well. But I guess I'm wrong.
It's crazy. All right. So what would your advice be now to someone who is a visa overstayer? If they've been they're here, they entered legally. Yeah. They've overstayed their visa. What would your advice be to them right now? Honestly, the advice hasn't really changed for me. Right, yeah. I think you're still in the same position you always were. It's just that maybe the likelihood of removal proceedings starting, or maybe the likelihood of detention has gone up. I'm not really sure that it has, because I don't think the numbers have actually passed Obama's yet. I think they're getting there, right? And that's such a great point, right? It looks bad, but it's actually not as bad as it has been. I think it's because of social media, and it's more polarized with the way how they're going about it. Yeah. Under Obama, you never really heard unless because they were very clear about their priorities. Yes. They're like, we want the violent criminals and drug and gun traffickers and people traffickers, right? They want the worst of the worst. Yeah. Who are already a done deal. Yeah. Already have a removal order. Already have these convictions. They're putting them on planes. There was no doubt about it, right? Now it's like, if you have a traffic infraction. Yeah, exactly. Yeah. So your advice hasn't changed. So what would you I would say, what I tell a lot of people is continue to follow the rules, right? If you don't have a driver's license, don't drive. If you don't have work authorization, don't work. Because this is where people are getting picked up. They're getting picked up at known places of employment that will hire people who are undocumented. Yeah. And they're doing traffic stops, and unfortunately, driving while black and brown has always been an issue. So, if you're a black or brown immigrant, that's still going to be an issue. Yeah. The difference is you don't just get the traffic infraction now. When you're also an immigrant, you'll also have removal proceedings may start. So just be more strict, follow more of the rules, stay home. Yeah. But how do they get out of that situation, though? Still file. If you are eligible, if you are in a real loving relationship, you have married because you want to be together, not because you want a green card, still file it. Yeah. Matter of fact, file it sooner than later, because we know how to overcome
a lot of these hurdles now. We don't know what tomorrow's hurdles are going to be, so file it now.
Yeah. What would you say to the person, because I've seen this question a lot, and I've also thought about this question, the people who are like, why even bother go to the court or to my ICE check-in or to parole if I know I'm going to get picked up? Why bother go to court if I know I'm going to get picked up by ICE?
The consequences are worse.
Yeah.
You don't go, now you're a fugitive.
Yeah.
If you don't go to ICE, that is. If you don't go to court, now you have a removal order. Now they can put you on a plane, right?
Yeah, and the reasoning behind that is like, okay, if ICE picks you up and you do have a relief, we can get you out.
Right.
But if you do not show up to court, then a removal order is entered, and then no, you won't have a chance for a bond hearing.
Right. Now the best we can do is try to reopen your case.
Yeah.
But you better have good grounds, because the judge can just say no before we even show up in court.
Yeah.
So.
Wow. All right. And since we're on this, a recent memo came out about I-130s, right? That no, filing an I-130 by itself can trigger deportation proceedings. So people don't get this confused, right? They're not saying if you are out of status and you file an I-130 and an adjustment of status, it will trigger removal. No, it's if you file an I-130 and you're already deportable, meaning you enter the country either illegally and you're out of status, and you file that by itself, because the I-130 by itself does not grant you any status at all. Yes, it has a pending, but it doesn't grant you any status. So what they're saying now is that if you file that, and like say you have criminal convictions or you have a previous removal order, or they know you're waiting and you're supposed to become a citizen,
right,
then they're going to send you an NTA.
Yeah.
What do you think about that?
I think it's pretty speculative on their part.
Yeah.
Because what do they know? They think they know they think they know your life, right?
Exactly.
But I feel like a lot of people are going to turn around and say, you don't know my life. That's actually not what's going on with me.
Yeah.
The standalone I-130 is like, there are so many reasons to file it. There's so many reasons. There's, like you said, if you are married to a green card holder and you're waiting for them to become a citizen so that you can now apply for adjustment of status. It's a strategy based on time, right? But that's best if the citizenship is soon. It's
very soon, not 3 years away.
You don't want to wait forever because that's too risky. And, overstaying all that time, it's just a scary anxiety, bringing type of status or situation to be in. So it's hard to say. I don't think it's the end of the standalone I-130. I still think that there are plenty of scenarios where if you plan for the worst and hope for the best, you might still be in a good position. If you want to file the standalone I-130 and maybe you actually qualify for a benefit that's only available to you if you have removal proceedings.
Yeah.
Right? There's several. There's cancellation of removal. And you can't file for cancellation of removal until you're in immigration court, if you're in removal proceedings. So, say you've been in the country for years, you don't have a criminal record, you've got U.S. citizen spouse or parent or children, you've got all the criteria to meet that status, to at least apply a prima facie application, right? But there's no way to get to court.
Yeah, exactly.
You don't want to file a fake asylum, to get to court. You don't want to get yourself arrested to get to court. You just want to, this family member's here. They can file the I-130 for me. Let's see what happens. You might do it on purpose, honestly, but
I know. It's
scary because you could be detained while that's happening.
Yeah.
But, we talked about it already. There's lots of reasons why you could get released, even if you are detained. So.
Yeah. What are your thoughts on the Dignity Act, right? I've been getting so many questions on the Dignity Act, which, as you know, it was introduced to the House, right? But it's not, they have intentionally said it's not an amnesty.
Right, it's not.
Right, it's not an amnesty.
Not even close.
It's so immigrants can have dignity in terms of being able to travel, being able to work legally. But the eligibility is you have to be in the country since December 2020.
Right.
Right. You would have to pay a fee of $7,000 over the next 7 years.
Yeah, I think there's like $1,000 per check-in or something like that.
So like $1,000 a year. You have to give 1% of your salary, and you can't have any major criminal infractions, right? Do you think that is going to get passed?
It's the trade-offs. The issue is what they're wanting in exchange. I mean, there's always a catch in Congress, right? So
exactly.
What they want in exchange is national E-Verify.
Yeah.
And if you're not familiar, E-Verify is basically a free to employers online system where they are able to check whether or not their employee has work authorization, is legally employable by you. It is currently only required in some states and at different levels. Some of them require it for public businesses, like government jobs. Some of it require it for government jobs, and if you have if you're a private company but you have a government contract, so now your employees have to go through the E-Verify system. And I know there's a third level as well. I don't remember exactly how they do it, but it's not currently required everywhere. It's state by state. And if it becomes national, I'm not sure how extreme is it going to be. Is it going to be everybody everywhere for every type of job? Is it still going to be public or also private companies? I think that's really, really tough for folks who are working to survive under the table. You know, they're just trying to eat, feed their children, you know, find a place to live, and they may not yet be authorized to work. That's going to be a very serious consequence of the Dignity Act. But I also think that, I don't know, are they getting enough out of it? They're not getting a status per se.
Yeah.
It's not even a path to citizenship. No,
because it doesn't lead to our green card.
Right.
It doesn't lead, but it does keep you here, keep you out of ICE radar.
For now. I mean,
it gives you a work permit. You can travel in and out of the country, but I would say it buys more time for you to find a relief instead of living in the shadows.
Yes. So for some people, I think it would be their only path to survive.
Yeah. Do you think the 5 years is too short though? Like, or is the right?
I think the goal is maybe to make it renewable or something like that. I mean, I don't know. What is?
No, in terms of the eligibility, like what about the people who have been here for 3 years?
Right. Yeah, I don't know. I'm hoping that maybe they extend it so that in a couple of years they'll say, okay, 5 years from now, you know. Got it. I can understand why they want a 5-year look back. 5-year look backs, I mean, they do the same thing to green card holders. When you apply for citizenship, they look back 5 years.
I never thought about it that way.
Yeah.
Yeah.
So they want to see, what have you been doing since you've been here, if you've been here at least that long. But I guess I'm just worried that it could go the way of DACA and TPS.
I know, where you're just in this temporary hold forever.
Yeah, the action against you is deferred.
Yeah.
So, you know, there are people who have been here for 30 years.
I know.
They crossed the border maybe a few times. And somehow have stayed under the radar since the last time and own businesses and make money and employ other people and don't get into any kind of trouble at all. I would not be motivated if I was them to turn myself in now. And
because then suppose they cancel or they cancel TPS now, but now they know where you are.
Exactly.
And it's gotcha. You know?
I kind of feel like that's the point, right?
Yeah. Oh my God. All right. So as we come towards the end of this, marriage-based petitions are also going to be more scrutinized, right? Yeah. What are your top 5 red flags for you?
Oh, okay.
When you're looking at a marriage-based file? I have my top 5. You tell me your top 5.
Or what I tell them USCIS is looking for?
No, well, when you are going through your file, when we retain the client and you're like, this is a red flag. What are your top 5 red flags?
Okay, so I'll do a little parallel. So immigration, they might look at multiple marriages, but I look more at multiple marriages with multiple immigration applications, because people will be married multiple times and maybe you get married 3 times, but you only have 1 immigration application out of all those marriages. But if each time.
So you're saying if you look at a petition and they've been through 4 marriages, and the U.S. citizen has done an immigration petition, all 4.
Yes.
That's a red flag.
It's a red flag because to me, I don't know if the U.S. citizen even realizes what's happening. I think the serial monogamist may be convincing them that this is love to get their green card.
Okay.
Right? It happens, right?
Yeah.
But again, it's rare. That's why it's a red flag.
Okay.
Because if I see that, I'm like, oh, this is interesting. I don't see this very often.
Yeah.
So it's a red flag.
Number 2.
Let's see, what else? Living apart.
Yeah.
Living apart is tough
because,
you know, I get it. In this economy, especially if you're working under the table, sometimes you have to go where the work is. But sometimes they're not working under the table and they're still living apart. Yeah. And I need a great explanation. I need to see, how much are you making? What are you doing for work? Is this really something you cannot find?
Yeah.
Where you and your spouse could live together? Yeah. You know, maybe your spouse travels so much for work that it doesn't matter. That's why you took the faraway job.
Yeah.
I need a good explanation. Yeah. That's what it comes down to.
And it has to be like an ironclad one because, I mean, 90% of those get denied.
Yeah.
Yeah.
I need to see a strong reason why you have decided to have a long distance marriage.
Yeah. All right. Number 3.
Let's see. Number 3, outside babies.
Yeah.
That should probably be number 1, actually.
Yeah.
Outside babies.
I'm glad you brought that up. Like I haven't spoken about that in a while. Yeah, like people having the children outside of the marriages and just think they're gonna file and it's fine and there are no questions about it, or they don't want to put it in the application.
Right. I don't have a baby. Yes, you do.
Yeah. People. So immigration, right? They pull the records for vital statistics. They will tell if your name is on a birth certificate.
Yeah.
Or on another application that links you to a child.
Yes. Yeah.
You know, so they know.
They do. I had one come up where it was the U.S. citizen who had the outside child. So they're both from the same country. He's a U.S. citizen. He lives here. She's here waiting for her application to process. He travels on a business trip and has relations with housekeeping. Has this outside child, but recognizes the child and tries to do a CRBO at the U.S. Embassy in their home country. Tries to get citizenship for the child, basically, because the child is born to a U.S. citizen parent. And I get that you want to take care of your kid and recognize them and give them the benefit of U.S. citizenship. But now they're looking at the situation as, okay, so who's your real wife? Because it's not the one you left in the U.S. because she has no kids. Yeah. With you. But this, you know.
And it happened during the marriage.
Yeah. And also, where was this business trip? Because it seems like you just stayed at the hotel. So, are you just visiting your housekeeper wife or?
Yeah, and those are things and that's how the officers think.
Yeah.
All right. So what's number 4?
Let's see. What's a good one? Well, speed, right? If it's really, really fast. If you meet, get married, and apply, like back to back, just a few months apart in between each thing. Of course, it happens, right? People do fall in love at first sight.
And there's this third person in there who is paying for everything. Yeah. Driving them everywhere. That's the red flag because that might be the real relationship.
That's the baby daddy or the wife that they divorce so they can marry this U.S. citizen and then get the green card, divorce, marry the original spouse, give them status.
And the thing is, what they don't understand is if we as the attorney can see it, USCIS, who has more resources, they will see it and they will find it. Yeah. So how do we overcome all these red flags and present a proper case in 2025 with the extra scrutiny that you're seeing? What are we doing differently?
I don't know that I'm doing anything differently, to be honest. I have been burned a couple times on some fake relationships. Wow. One, I caught it before I filed it, and I dismissed them as clients. One, I found out at the interview with the officer, and I was like, oh my God, I have to hold a poker face till we leave this room. I'm not saying another word. Because I need to get off of this case, but I can't get up and walk out and be obvious. So exactly. but because I never did, and I especially now want to file a fake case. I don't want any parts of it. Our license is on the line. We want to make sure that whatever we present is the truth and is supported by data. So I think, I love to see couples together. I like to do the consultation together. If one calls, I like to hear them say, let me talk to my spouse and we'll get back to you. Actually, can I call my spouse on three-way? He might have questions too. I love that.
Yep.
I'm like, I'll take the time because that means there's a real marital interaction between the two of you. And the same at the stage when we're getting ready for the interview. I want to hear them. I want to watch them interact. I kind of want to see them argue a little bit because when they get a little heated, that's when it's like, oh, this is a real couple. For real.
And that's one thing that I've built in my firm, which you align with, is we will not send out a package unless we think it's ready.
Yeah.
Right? If I think a package looks like the officer is going to say this is a fake marriage, I mean, it could be a couple that have been together for 5 years, but you don't have the right evidence, you don't have the right documents, we're not going to send it out. And people get upset. They're like, why aren't you sending out my case? Well, because they will think that this law firm is under fraud.
Right.
Or two, it's going to put you in a worse position than when you met me.
Right.
And then you're going to say, oh, this attorney just taking our money.
Yes.
And not getting us the result. No, but you have to send in the proper documentation. I mean, we can help you in terms of saying, all right, these are the things that we need. This is how we put it together. But we're not going to send out cases that we think will put you in a worse position.
Yeah. Yeah, so, I don't want to ever set anybody up for detention because nobody wants to be inside.
And then especially because the denial leads to removal.
Right.
Yeah.
Yeah.
As we close, right? What would you say is the biggest change that you've seen this year? I mean, it feels like we've been in a 3-year run in 2025, but it's only been 8 months.
Yeah.
What has been the biggest immigration change that you've seen?
For me, removal defense has gotten so sticky.
Yeah.
And it was piece by piece.
Yeah.
Right? They started, I'm not really good with chronology, so I don't remember which happened first, but we've got matter of Cooley, which is now making it difficult or impossible for someone who entered at the border to be released on bond if they're ever detained, right? We've got a memo from April.
Hold on a second. So basically she's saying a court decision, which is now the law, which says that if you entered illegally, then it's
illegally.
Yeah. if you entered or paroled within the last
2 years.
2 years, then it's very challenging for you to get out of bond if you're detained.
Right.
Yeah. Sorry.
There's very specific scenarios where you can try to beat that, but it's much harder. I actually had one where bond was denied before the hearing. I showed up at the hearing and the judge was like, I already denied that. I'm like, excuse me? So there's that.
Yeah.
They're like building, it's like a brick by brick, right? So the other thing is a memo from April 11th, I believe it was, authorizes immigration judges to make a decision on asylum applications without testimony. They can decide on just the documents to deny you and that's it. You can come in on the day of your hearing thinking you're about to testify. You've really gone through your application, readied yourself, prepared questions and answers for your hearing, and you get there and they're like, oh yeah, we're not going to go forward because these documents don't show enough evidence that you're actually eligible for the benefit.
Yeah. So like those are the people that you see getting picked up at the hearing. Yeah. Or saying their case already got dismissed.
Right. Case closed before we even really do anything. There's CLP, oh gosh.
People, you see, she knows all these court cases. She's keeping me on my toes. She knows all the court cases. She's on it, but
yeah, the circumvention of lawful pathways. So that is actually undivided, where they're basically saying if you entered between was it May 11th of 2023 through 2025? Is it this year?
2025, yeah.
Yeah, through this year. If you entered through that time and you did not have parole or some other pre-authorization to enter the border, you can't even apply for asylum. Like you can't even submit the form. You can submit the form, but they're not gonna. They're not gonna entertain it unless you meet one of the exceptions. There are a few exceptions. They're kind of hard to meet. Well, I have arguments against that too, but it's just piece by piece. There are fewer and fewer opportunities to have your day in court on asylum. So I don't know how people are doing it by themselves. I have no idea.
I don't understand how people try it.
Because there's no way they know matter of Cooley. There's no way they know the CLP law. There's no way they know about the April 11th memo, because that wasn't distributed to the public. That was distributed to the legal community.
And the document preparers don't know it either.
Right. Definitely don't ask them for help. But so these things, bit by bit, are making it so that if you're not up to date on the laws, you can spin a lot of wheels and spend a lot of money just submitting things, and it goes nowhere. So you have to be prepared to argue all of these things. I mean, there's always been the 1 year deadline for asylum. That's been around forever. But now there's all these other requirements, all these other hurdles you have to jump over to even apply. So court has it's breaking down a little bit. And it's upsetting because at least you could have your day in court. That's one thing that I always felt like, well, at least there was that. Even whatever happens on the outside, you apply, you don't get approved, at least you can have your day. So I think that anyone who gets an NTA needs to call a lawyer ASAP.
Absolutely. Well, people, thank you so much for joining us. People on TikTok and Instagram, we appreciate the time. I know there are questions, right? We're doing a webinar next week? Okay, so August 15th, people, around the same time, same place, we're going to be doing an immigration webinar where, yes, we'll get your questions answered if we can get to all of them, but you will also have the opportunity to download the Clarke Code, which is our document. It's an immigration starter pack, right, with all of our tips, all of our strategies. It's free, right? It's an ebook that you can download. Go to clarkecode.com, download it, and we'll be going through some of the deportation defense best practices for marriage-based business, investment visas, and how to maintain during this Trump administration and the changes that are coming. So you can go to clarkecode.com and you can download the Clarke Code. And then also, if you go to any one of @Attorney Sekou pages, you can go in the link and you can register for this webinar and live next week, Friday, August 15th at 6 p.m. All right. So thanks, everybody. Thanks, Attorney V.